Hi, everyone. I hope you all can hear me. My name is Erin Jock. I'm the conservation agent for the town of Amherst. Um, I am joined here tonight by Alex Weisheit of KP Law, who's going to be presenting tonight on solar siting. Um, so I'm going to read Alex's bio and introduce him before he gets started. I think Alex is going to take questions throughout the presentation, and Alex and I are both co-hosting, so I will try to facilitate the question and answer while Alex is presenting. And Alex, if you feel like you want to take the reins on that at any time, feel free. If anybody wants to, I can either add you as a panelist or just allow you to speak. And what I probably do is default to having people join as panelists so that they can have a Q&A with Alex individually um, and then ask you to sort of rejoin as an attendee. Um, Okay, great. Quick intro for Alex. Um, Alex Weisheit is a member of KP Law and a principal attorney in the firm's land use group. He assists the firm's clients in all facets of municipal and land use law. He has more than 15 years of experience counseling clients on general municipal law, land use, and environmental law. Alex has represented municipal and private clients on a broad range of cases, including zoning and wetlands permitting appeals, business disputes, and real estate disputes before various levels of Massachusetts trial courts. He often represents municipal clients in enforcement-related litigation, including building code, sanitary code, wetlands, and zoning enforcement matters. Alex's experience also includes advising the firm's municipal clients regarding permitting issues and drafting of land use related bylaws and regulations. Alex is a former member of his local conservation commission and member of MACC. He's an avid outdoorsman and enjoys spending his free time with his wife and two young children. So thank you so much, Alex, and welcome.
All right. Thank you, Aaron, and thank you to everyone who's attending. Really looking forward to speaking with everyone about a subject that's near and dear to my heart, and that is solar permitting, the landscape for which is evolving as we speak. But we'll get into that towards the end of our discussion tonight. And my preference would be to kind of treat this as a conversation. So as I'm, talking and going through the slides that I prepared, if anyone has any questions at any point, feel free to interrupt. And, Aaron, if you want to just let me know if anyone's hands are raised, I'm happy to answer questions as we go along here. So I guess, am I able to share my screen here, Aaron? All right, let's
Yep,
see if
you
I
should be
can.
able to go share, and then as soon as you do, if you're not able to, I can usually grant
Okay, yeah.
permission.
Here we go. All right, is that showing? Oh,
There
okay.
you are. Yep.
Showing up? Okay. All right. Let's see if I can start the slideshow here. Oh, all right. All right. Is that showing up? Okay, great. All right. So we'll start by, basic disclaimer here that, we're kind of going over some general topics here, but if there are any, specific issues or questions that everyone has, you know, we can we can talk about those in a different setting, but I can't, give you any specific legal advice tonight. But I'd like to start by kind of talking about, in the zoning context, what is the underarching or overarching state statute that applies to solar projects generally, and that would be Chapter 40A, Section 3, which provides that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy, except where necessary to protect the public health, safety, or welfare. So, based on this language and the way it's been interpreted in case law and by the Attorney General's office when reviewing proposed zoning bylaws relative to solar. There's a presumption that the state legislature has a goal of promoting solar energy, and that is, definitely supported through this language, which is intended to promote solar projects. So the seminal decision that started in the land court and made its way up to the Supreme Judicial Court relative to regulation of solar through zoning bylaws is the Tracer Lane case, which came out in 2022. And the Supreme Judicial Court, held that while the statutory language of 40A Section 3 actually provides municipalities with a bit more flexibility than the statutory protections for other protected land uses, such as those for educational or religious or childcare uses, where the only way you can regulate those types of uses is with essentially dimensional type of regulations, things like bulk and height. Whereas for solar, there is a bit more flexibility, not unlimited, but a bit more. So some other points from Tracer Lane. The SJC held that the court's determination of whether a bylaw facially violates Section 3's prohibition against unreasonable regulation of solar installations will turn in part on whether the bylaw restricts rather than promotes the legislative goal of promoting solar energy in the Commonwealth. Now, this particular holding is cited by the AG's office very frequently, in my experience, when they're reviewing, warrant articles that have passed at town meetings that seek to, limit or regulate solar projects. There's kind of a balancing that the AG's office will do, but the underlying sort of legal standard that is always applied is, at the end of the day, is the bylaw promoting or restricting solar energy? So more specifics about Tracer Lane in that case. See a hand raised here.
Okay, so I will add Everald as a panelist. Okay, Everald, you should be able to unmute yourself.
I can, thank you. So is there any language that would, on its face, suggest that a bylaw restrict rather than promote? Like, is there anything that would be like obviously in your face?
Yeah. So, short answer is no. Classic. I see you're an attorney as well. Sorry to give you the classic lawyer response, but it's, it depends type of situation. So, basically, generally speaking, if a bylaw, I don't want to say it's a 50-50 type of proposition, but suppose that in Tracer Lane, the Waltham bylaw only allowed solar as of right in, I want to say, 2 or 3% of the city, which when you have a bylaw that excludes solar in that large of a portion of the municipality, that clearly would be facially invalid in the AG's eyes, because you're nowhere, you're not promoting solar at that point, you're restricting it. Whereas there are other bylaws that have been approved more recently where say solar's allowed by special permit in 50% of the municipality, as of right in maybe 30%, and then outright prohibited in the remaining 20% or whatever's left. So, if somewhere above 50% of the zoning districts in a municipality are either allowing by special permit or allowing as of right, then there's a decent shot that the AG, in my experience, would approve that type of a bylaw. It's not a it's not a bright line rule, but if a majority of the zoning districts in a municipality are either allowing as of right or by special permit, then more recent decisions from the AG would suggest that there's a good shot that they would approve that type of a bylaw.
So, so as long as there is allowance under like what you just said, special permit or certain other factors, then it's facially allowable.
Yeah, it's at the very least, it's not facially invalid at that point. Then it's a real balancing kind of discretionary determination for the AG. But in based on some bylaws I've worked on recently, which have more so dealt with battery energy storage. We'll talk about that in a bit, but the same reasoning would apply. If you're talking somewhere above 50% of the municipality that is either special permit or by right use for the solar related use, then you got a good shot of getting approved.
And is there any so with the special permit provisions, the town still has and retain the ability to determine where it can go, and that's not invalid.
Yeah, so when you're special permit in the context of solar is kind of special permit with a lowercase s, meaning if there again, if you're treating the special permit review more like a site plan type review, where you're not necessarily going to treat it like a discretionary type of special permit, then the AG at that point is more likely to view that favorably. If you're talking about a special permit review that is the normal kind of discretionary, is there an adverse impact on the detrimental impact on the surrounding neighborhood? And if so, then the board can exercise its discretion to deny. The AG may flag that as being more of a restrictive type provision. But, as you noted, yeah, if there are certain, and we'll talk about this more later in the kind of presentation, but if there are specific zoning districts where, that say they're particularly environmentally sensitive or very densely developed, then areas like that, the AG usually will look favorably on being more restrictive in those types of areas. Oh, sorry. I see there's another hand raised, but yeah, I want to make sure I'm answering your question, Everald. Do you have any other?
You are, thank you. And I'll stop hogging the mic for a minute. Yeah.
No worries.
So I just For whatever reason, even though I've tested this out, I'm not able to remove people once I add them as panelists. So what I'm going to do is allow to talk, but if anybody feels, anybody who has a question feels like they want to be brought in as a panelist so they can, see Alex face to face, I can do that once I allow you to talk. But I'm just going to start by allowing folks to talk, and then we can go from there. So I'll bring Doug in.
Hello.
Hi,
Hi, Doug.
Doug.
Hello. Yeah, you just touched on your example where a municipality might restrict solar development in environmentally sensitive or highly developed areas. What if you did the opposite and you met the 50% within the statute, within your bylaw itself, but in fact you were allowing solar in areas where it's unlikely or in fact prohibited to happen for environmental reasons. And, so do they look at the bylaw by itself in isolation or within the context of the environment in which it's passed?
Yeah, no, the latter. So they would look at it in terms of not just on its face what where the bylaw is saying it's allowed as of right versus not, but also as a practical matter in the areas where it is being allowed, if 98% of that area is wetlands, then that's not going to count
Okay,
towards,
good. Thank
right?
you.
Yeah. All right. Did
So,
someone else have the hand raised there?
yes, so I'm going to remove Doug, but Doug, if you have if you could put your hand down, and if you have further questions, you're welcome to jump back in. And I will add Jacob.
Hi, I was wondering if you could comment a little specifically about the town of Amherst, because how would it, Amherst has something like 50% of our property as nonprofit owned, mostly by institutions of higher education. And then another, I don't know, 30% is roughly for recreational use. And so roughly 80% of our land is already predetermined. How would that go into this conversation?
Sure. So, I guess it would depend on if there are, uh, again, if there are practical impediments to placing solar on within certain areas, like say, properties that are owned by UMass, then those areas would not be part of the AG's consideration for how much of the area within the town is actually available for solar use. So the AG would be looking at really focusing on the areas where it's both legally possible and practically possible for a solar facility to be sited. And out of those areas, the question is there, something over 50% that at least is allowed by special permit. So that's kind of how that would work. I think for Amherst is there would have to be consideration of the areas that are both, not subject to some type of recorded restriction or are composed of entirely of wetlands or other practical impediments to development of these types of facilities. And out of those areas that are actually potentially sitable, how much of that portion of the town is still being restricted, and how is it being restricted by the zoning bylaw?
Does that answer your question, Jacob?
Yes, I think I might be muted.
Okay.
Oh,
Yeah.
All right. All right.
Lord.
I will remove you, but if you
Yeah.
want to ask another question, please raise your hand. Okay. Okay. Carry on,
Uh,
Alex.
very good. All right. So just a few facts here from the Tracer Lane decision. So in that case, there was a developer trying to develop a large scale ground mounted solar array in the town of Lexington, but the access to the parcel where the project was to be sited went through the city of Waltham. And the Waltham ZBA denied access because they considered the access to be part of the underlying solar use. And at the time, their zoning ordinance prohibited these types of large scale solar projects in everywhere but 2% of the city. So the SJC ended up ruling that that the bylaw could not be applied to restrict solar in that type of way based on at that point where there's only 2% available, both the AG and the court would hold that that type of bylaw is just facially invalid and can't be applied to restrict these types of projects. Let's see. So again, yeah, the court kind of highlighted that these types of solar systems are key to promoting the legislature's goal of promoting solar energy and renewables in the Commonwealth. The court explained that whether a bylaw facially violates Section 3's prohibition against unreasonable regulation of solar and related structures turns in part on whether the bylaw promotes rather than restricts this legislative goal. And again, that's where we get into what we've been discussing already, which is kind of this balancing of, okay, where as a practical matter can solar be sited? And out of those areas that are available for siting as a practical matter and a legal matter, how much of those areas are allowing either as of right or with a special permit, allowing these types of projects. And that's what's going to form the basis for the AG's either approval or denial of bylaws seeking to regulate solar. So finally, the court held that while municipalities do have some flexibility to reasonably limit where these types of solar projects may be sited, the validity of any restriction ultimately entails balancing the interest of the bylaw against the impact on the protected solar use. All right. So I'm not sure, Aaron, has Amherst had any battery energy storage facilities that have been applied for or constructed yet?
Yes, we do.
Okay, and they're aren't
Not
they?
not a standalone yet. Um, I believe the ones that we've permitted are associated with existing solar facilities. We did have a standalone permitted, but it has not yet been constructed.
Okay. All right. So folks are at least kind of generally aware of these types of projects. Some of the communities I work with have really been inundated with applications for these types of projects recently. And this Duxbury Energy Storage versus Duxbury ZBA decision held that these types of battery energy storage projects essentially are tantamount to a large scale solar project, and they're entitled to the same types of protections under 48.3 as if they were a large scale solar facility. So in this case, Judge Resnick at the Land Court determined that these BESS projects qualify as a structure that is built to facilitate the collection of solar energy. And that initial definition from 48.3, if we went back and looked at that, you would see there's that or clause of, is it actually generating the energy, or is it facilitating the collection of the solar energy? And here, she relied on that second part of the clause to say that these BESS projects are facilitating the collection of solar energy, and therefore they're entitled to the same protection of 48.3 as large-scale ground-mounted solar. So we represent the town of Duxbury as well, and we've worked with them on this appeal. The ZBA appealed Judge Resnick's decision to the appeals court, and some of the arguments that we were hoping to make before the applicant ended up abandoning the project, and the appeal ended up being dismissed before the court made any rulings, unfortunately. But some of the arguments that we were planning to make on appeal were related to the fact that it's not possible, or at least not readily available, to determine what composition of the energy, they call it a grid mix of energy that is stored at these facilities, how much of that is actually comes from solar or renewables. So our argument would be, well, you're saying these facilities facilitate solar, but you can't even define or specify how much of the energy that's being collected is actually coming from solar. So if it's a really minor portion, or less than 50% of that energy is generated by solar, then how is it appropriate that these facilities are entitled to that same protection as a large ground-mounted solar, which is 100% of that is coming from renewable and solar generation. So unfortunately, the court wasn't able to rule on that argument, as the project was abandoned. Although I do have a couple other appeals currently pending in the land court that may very well make their way back up to the appeals court. So I think at some point in the future we will get a appellate level decision on whether or not these structures really should be entitled to this same protection as large scale ground mounted solar. But for now, the only decision specifically addressing the issue is this Duxbury Energy Storage case. So our advice at this point is that these types of facilities are entitled to the same protections as 48.3 for large-scale ground-mounted solar, and the AG's office maintains that position as well. So when they're reviewing zoning bylaw provisions that seek to regulate BESS, they're applying that same standard that we've been talking about for large-scale solar. So where as a practical matter can they be cited, where legally speaking can they be cited, and is there somewhere above 50% that is either special permit or as of right where they can be cited.
Alex, we have a question and answer that came to me in a written form, if I can read it to you.
Yeah.
It says, what does promote mean? Does it mean a bylaw must encourage or incentivize solar development in some way beyond the status quo?
So not promote essentially means allow. It doesn't necessarily mean that you need to be encouraging these types of projects. But the AG's office, when they're reviewing proposed bylaws, will again, apply that balancing test and determine, based on the portion of the municipality where solar or BESS is allowed as of right, or with a special permit, if it's somewhere above 50%, then in the AG's eyes, that would be promoting rather than restricting these types of solar developments. So yeah, it's not like you need to have any language in there that's really, encouraging these types of facilities, but you do need to allow them in a significant portion of the municipality. Okay, so all this said, I mean, what are some reasonable restrictions that bylaws may impose on solar projects that the AG's office has upheld when reviewing proposed bylaws? One of them is to prohibit solar in certain environmentally sensitive areas. I can think of an example for the city of Amesbury, where a developer was proposing to site a facility right next to Lake Attitash in a groundwater aquifer protection district area. And, thankfully, the city council had already initiated a zoning ordinance amendment before the application came in. So the city's zoning ordinance was able to be amended such that solar was prohibited in that district based on the environmental concerns. And ultimately, the applicant ended up withdrawing that application. But yeah, if there are environmentally sensitive areas, it is reasonable to restrict solar there. And they also, from a wetlands permitting perspective, they would need to meet all applicable performance standards. So there's not a similar exemption that there is on the zoning side on the wetland side. You're going to need to meet your performance standards under the Wetland Protection Act and under the Amherst bylaw, wherever you're proposing to site these types of facilities. Some other examples of potential conditions or restrictions would be limits on clearing of vegetation. Again, that's kind of that can be a concern from a wetland perspective as well, obviously. Reasonable mitigation can be required when there's a significant amount of forest habitat that's lost. Reasonable lot size limitations. I can think of one bylaw for one of our Western Mass towns where I think they imposed a 10-acre limit, and the AG said that was reasonable. And then reasonable screening requirements. So especially if the facility is being proposed somewhere that is in close proximity to residential areas or roadways, then municipalities can definitely impose significant screening requirements for the facilities at that point. All right, so now we can talk a bit, and I'm just going to give kind of a general overview of the recent amendments that will be going into effect as of October 1st that have come from the 2024 Climate Act and are going to result in some pretty significant changes to the permitting pathway for these types of projects going forward. But KP is working on some comprehensive guidance for all of our clients, as well as preparing potential draft bylaws for consideration. So that is a work in progress. DOER's regulations just came out. I think it was, maybe a couple weeks or a month ago. So we're in the process of working our way through those, but I thought it would be helpful to at least give a general overview here, and then we can certainly supplement that once we get more detail. Yep, go ahead, Aaron.
Alex, I wanted to just two quick things. The first is I lost your presentation. I don't know if you stopped sharing or if that
Oh,
was I'm kind of toggling back and forth with the Q&A
um,
box. So I don't know if the presentation is just not displaying for me or
still says I'm sharing, but let
mm,
me
okay.
stop it and try it again here.
Okay. And then I also have two questions in the Q&A box. I don't know if now is a good time to field those before you move on to the next.
Yeah, absolutely.
Okay. Um, okay, so others are saying they can see the presentation. I don't know why it's not on my screen. Interesting.
Oh,
So the first question is, was the Amesbury project in a groundwater protection district both solar and BESS or just solar?
that was just a large scale ground mounted solar.
Okay. And I'm going to dismiss these as Alex answers them. Um, do you have examples of reasonable mitigation for carbon sequestration in the context of solar proposals that suggest large-scale forest clearing to proceed?
So um, there actually was a case, I think it was out of Hubbardston, um, at the land court where getting the judge, I think it may have been Judge Roberts, ended up upholding a denial of a large scale solar facility project because of the amount of forest that was proposed to be removed for it. And she determined that um, the the net adverse impacts to the environment from removing that type of pristine habitat and um, amount of trees that are contributing to carbon sequestration, um, that it would be kind of a net negative for the environment to put solar into that type of a parcel. So that case, I believe, is still pending its way up to the appeals court. But generally speaking, there is a significant amount of room for municipalities to require mitigation for these types of projects. And particularly if you're talking about clearing out a lot of trees, then I think a significant amount of replanting of trees would be a reasonable form of mitigation. Maybe requiring contribution to a tree fund to compensate and allow for planting elsewhere. But yeah, there's definitely flexibility and room for requiring significant mitigation um, in these, particularly when you're dealing with unaltered sites.
Okay, so that looks like all the questions in the question box. I do see somebody, Pamela Rooney has a question, so I'm going to allow her to talk.
Hi, thank you, Pam Rooney, 42 Cottage Street. Um, this is very exciting to have this presentation tonight. Um, as you probably know, we are developing our own solar bylaw, which probably once the planning board reviews it in the next month, will be coming to KP Law for consideration. So I hope KP Law doesn't spend a lot of time drafting its own bylaws. We think this is a pretty comprehensive one based not only on what we developed prior to the state promulgating its own guidelines, but also incorporating what the state has put out. I
Yeah,
was going to comment on the percentage of land mass, if you will, being made allowable for solar. And I just don't think that we should get too worried about where we're allowing what percentage of land we're actually allowing for solar development. I think our bylaw is going to be very proactive. It says, of course, we support it. You know, this is the mantra. We support it, but we
yeah,
have reasonable conditions that we want to meet. Also, one of the things that you may have touched on that very last slide is that the state, prior to anyone coming forward with an application, must go through a site selection evaluation, site
mm,
assessment.
yes,
And that in itself will determine, I think, it will address a lot of the environmentally sensitive concerns that people might have. So we could
yeah,
open up the whole town, but if they're environmentally sensitive or whatever, they may not, in fact,
yeah,
allow for development. One of the reasonable conditions that we made sure we put into our bylaw is that we have drinking water protection
mm,
zones. And so we name those particularly, both for private water wells and for public drinking supplies. And I think that's something towns should have no qualms about doing, because that is a key resource for any town.
yeah, agreed.
I think that's it. Thank you.
No, thank you. Yeah, no, I was aware that that you guys are working on a solar bylaw, and we certainly look forward to working with you and reviewing it, um, and the good news, as we'll get into when talking about these recent amendments from the 2024 climate bill, is that at least with regard to smaller scale projects, the legislature is not overriding the ability of municipalities to apply your own local zoning and wetlands bylaws. So that's hopefully a good segue here. Let me if I can see if I can start sharing my screen again. All right. Okay. Oh, oh, there we go. Is that showing up?
Yes, thank you.
All right, great. All right. So 2024 Climate Act. This will create a more streamlined permitting process. There will be a single permit application that will, and responsibility will go to a local government official who's designated by the municipality to kind of oversee this process of making sure that all local boards that have jurisdiction over the project, so whether it be the ZBA, Planning Board, Concom, that all of the local permits that are required are issued within 12 months. At this point, there is zero flexibility to waive that 12-month requirement. And the consequence for not issuing a permit within that 12 months is a constructive approval. And you would be, losing your local jurisdiction and just rendering the project subject to the Energy Facility Siting Board imposing whatever, their state standard conditions would be. So generally, that's what will happen. What the good news is that at least for smaller scale projects, so for ground mounted solar, smaller scale would be less than 25 megawatt hours. For BESS, I believe it's less than 100 megawatt hours of storage. Anything under those thresholds would still be subject to all local permitting and review. Larger scale projects above that threshold would be handled exclusively by the State Energy Facility Siting Board. But municipalities would have a right to intervene and at least kind of have some input in that process, but nowhere near the amount of oversight and authority that you would still have for the smaller scale projects.
Alex, I have a question in the question box. I don't know if you want me to keep interrupting or not.
No, please do. Yeah,
Okay,
please do.
okay. Um, so the question is from Judy Eisman, and she asks, has anyone considered the actual environmental loss if after cutting a large amount of trees, planting new trees is the best thing to do? In fact, it's my understanding that there is still a major loss of carbon sequestration in that situation. Better, in fact, to leave the forest as it is, since not every town should really have the same amount of solar if the town is mostly forest.
Mhm. So that is the argument we're making on behalf of Hubbardston, which is that um, yeah, you at a certain point you can't really adequately provide mitigation when you're destroying that much forested area. Um, Remains to be seen what the appeals court will think about that. But I do agree that there becomes a certain point where it's hard to you know understand or come up with ideas for mitigation that really will be adequate to compensate for what's being proposed and will result in a really significant loss of carbon sequestration. Um, so it remains to be seen, how the appeals court will treat that. But again, I do think that that issue in particular is a basis for significant mitigation when you're talking about altering what are currently undisturbed forested sites. All right. Let's see. All right. So with this new proposal under the 2024 or new process rather under the 2024 Climate Act, some considerations and good for you guys that you're already working on a new solar bylaw. And that once it goes into effect will be applicable to the smaller scale projects going forward. So it's going to be incumbent on the local government official who is appointed to oversee all of these permitting processes and make sure that they're all occurring in a time frame that will result in all of the necessary permits being issued within that 12-month time frame. And the AG is actually, or sorry, the DOER has recommended that that municipalities really try to focus on something closer to a 10-month time frame, so that there's not issues bumping up against the 12 months, because at this point, unfortunately, there's zero flexibility for extensions. So, Aaron, I hope you're looking forward to taking on some new a new role here. You gonna volunteer for this one?
I doubt I will be volunteered for that role. I think it's a little over my head.
It really sounds like quite an undertaking. So.
Yeah. Yeah. I did have a question about that one, but I feel like I lost it, but it will probably come back to me.
Okay. No problem. So yeah, as I was just referencing, the local government representative will be appointed and will kind of oversee all of the different permitting processes that are happening and ensure that before that 12-month deadline hits, that each of the permits is included in a package, be they approvals or denials, and they will all be sent up to the State Energy Facility Siting Board, and they will complete their final review. If it's a approval, then they're just going to be looking at the conditions to determine, whether or not they're permissible. If it's a denial, then you're dealing with an appeal situation where our understanding at this point is that it will be a de novo adjudicatory appeal before the Energy Facility Siting Board, which is going to be a significant undertaking in terms of providing pre-filed testimony, and will require a lot of time and effort for that type of an appeal. But it's kind of similar. I know, Aaron, you and I worked on, we had at least that one appeal that was made up to the Office of Appeal and Dispute Resolution at DEP. It's a similar procedure there where the parties would submit pre-filed testimony from their respective experts, and then there would be cross-examination of each of the parties' expert witnesses, and then the presiding officer would render a decision about the validity of the permit denial.
Alex, my question that I had just came back to me, and I feel like it's a really important one. We've recently had a couple situations where we've had either turnover on the boards or absences of board members that have caused issues where we have not had a quorum, or we've been in a situation where over the course of review, we've lost the ability of voting members to participate. And I'm just curious how that will play into this 12-month deadline. As we approach the end of the year, when this moves to where we've got to start implementing it, how is that going to come into play? Like, I know with Concom permits, if we lose a quorum, we're put in a position where that we say, you have a tight deadline to get us responses, and if you don't, we have to deny for lack of information. Would it be a similar kind of scenario here?
Yeah, I mean, unfortunately, in the worst case scenario, if you lost a quorum at a point before an order of conditions was issued, and there wasn't adequate time to really kind of restart the process with a full quorum of the commission, then yeah, your only option would be to deny for lack of information. And unfortunately, I would anticipate that the Energy Facility Siting Board would, they would essentially treat it as the board probably waiving authority under the local bylaw, which would be unfortunate. But yeah, hopefully that won't be an issue, but it is a valid concern, definitely. All right. Yeah. So what are some provisions that bylaws should include in terms of aspects of this new permitting process? So one would be, identifying who the local government representative will be. And presumably these are already in most of your bylaws, but setting permit fees, detailing, which boards are going to review what aspect of the project, outlining the process and timeline to compile the individual decisions from the various boards that have jurisdiction, and then issue that consolidated decision incorporating all those various decisions within the 12-month time frame. Yeah, and then again, the note that at this point, no extensions are permitted, unfortunately. So some aspects of a potential bylaw that may be included. Potential community benefits or mitigation, maybe host community type agreement for some of these projects where there are significant impacts. Again, you can require significant mitigation if a lot of impact to the environment is proposed from the project. Peer reviews are always encouraged. Requirements for decommissioning and surety for these projects are pretty standard and definitely should be imposed. And then again, you're not waiving any of the existing bylaws on the books, or that you will be putting into place in the near future, hopefully. So if there are any sort of setbacks or other dimensional requirements from those bylaws, be they wetland setbacks or zoning setbacks, things like that, those are all still applicable.
Alex, we have a couple questions in the question box. So the first from Steve Roof is, how is the carbon sequestration benefit of a proposed solar field calculated?
I admittedly, my scientific knowledge is not adequate to really answer that. But yeah, I mean, if I were working with a board on that type of issue, my recommendation would be to hire someone who is an expert and scientist who could make that type of determination. I imagine there is a scientific method to it. I don't personally have that knowledge to share, unfortunately.
Fair enough. I have a question from Hilda Greenbaum, which is, what approximate acreage is associated with the power limits? I think she's talking about like the sizing of the facilities based on their kilowatts. Like, what does each equate to in acreages, I think is what she's asking.
Yeah, that's another technical question that I could probably answer generally based on some recent projects I've worked on. So I'm trying to think of one well, yeah, and again, it kind of depends on the density of the paneling, but yeah, I struggle to give a definitive answer there. I do remember a project recently, I believe was 50 kilowatt hours, and it was around 5 acres that was occupied. So what would that be? I guess 10 kilowatt hours an acre. But yeah, it really depends, I think, on the density of the panels and the types of panels, and there's a lot of technical and engineering questions that would go into that determination.
Yeah, I would imagine too, as technology advances, that panels may end up having a greater kilowatt generation capability.
Absolutely.
So I have a question from Jeff Bagg, which is, does local permitting include issuance of a building permit?
Yes.
Okay.
The building permit will not, cannot be issued until the Energy Facility Siting Board issues their final decision. I'm not
Oh,
sure.
so that would mean that the city or town would issue their overall approval and then there
Yeah,
would,
so basically all the boards would issue their decisions within the 12-month time frame, and then the local government official would um, combine all those into a package that would be submitted to the state, to the Energy Facility Siting Board. And then the state would have a certain amount of time to review that and either approve or make modifications. And then once the final decision from the EFSB is issued, then I think once the appeal period expires, then the applicant can apply for a building permit at that point.
okay. So it's not sort of anticipated that that would be part of the initial
No,
approval.
I don't think so. No, I think it would be, my understanding is it would be after.
Okay, got it. So maybe we could just
Um,
clarify that at some point
I
in the
can clarify,
future.
yeah, I can definitely clarify that. Yeah.
Okay, that would be awesome. Thank you, Jeff, for that. That's a good question.
Yeah.
Um, okay, and I'm just dismissing these because I'm getting like a long list.
I know.
And this is kind of, I don't know if this is a question or just a statement, but this is from Lenore Brick, and it's not just carbon sequestration. Forest clearing risks losing years of evolving ecosystems that impacts natural processes, including hydrological cycles, think floods, drought in climate disruption era, soils and microbial health, biodiversity, and pollinators, fragmenting habitats, all hurting public health. The state has blind spots as it's perpetuating an unnecessary conflict between protecting ecosystem health and promoting renewables as it's trying to do both, but without a comprehensive strategy and holistic perspective. Seems kind of like a statement rather than a question, I guess.
Well, and yeah, I don't disagree with it, but
Uh,
um,
Okay.
yeah.
I'm going to move on to the next one. Answer to last question is minimally 4 acres to megawatt DC and up to 7 to 10 depending on buildable land features. That's from John Pepe. I'm not sure I totally get that. I think that was related to Hilda Greenbaum's question about the size of the
Yeah. Yeah.
facility.
And again, I think it varies depending on the density of the panels, the types of panels. So it's hard to give an exact
Yeah.
number there.
Okay. So I have one from Stephanie Ciccarello, our sustainability coordinator here in Amherst, and she says it should be noted that there is a significant 60-day pre-filing process that is meant to deem a project application complete before it is submitted. That actually
Yeah,
starts the 12-month process. This point hasn't been stated clearly, but it's an important part of the process and it includes public notice.
that is true. Yeah. So the EFSB will make an initial determination about the site suitability, and only yeah, the um, they're correct that the 12 months will start after the state deems the site suitable under the criteria that is being developed.
And then we have one more. Thank you so much for fielding all of these, Alex.
Um,
This is from Jason Dorney, one of our Conservation Commission members, and he's asking, can local bylaws require utilizing impervious areas example, parking lots, rooftops, roadways, etc., for building before any impervious areas?
Um, so uh, I think that would depend on. I'm not as familiar with if the stormwater provisions that you guys apply, um, but assuming that you do have limitations on total amount of impervious that might trigger stormwater permit requirement, um, or if we're talking about a project that's within wetland jurisdiction, at that point, I think there is more discretion to require pervious surfaces rather than impervious. And certainly stormwater runoff is a big concern for these types of, for large scale ground mounted solar, when you're dealing with the increased velocity of stormwater coming off of the panels. Stormwater can be a big concern. So yeah, I think requiring pervious is always an option when you're in wetland jurisdiction or when you're triggering stormwater permitting requirements.
So we have two more questions that popped into the question box. Alex, I don't know if you want to field them now or if you want to hold to.
Yeah, no, I
Okay.
think I'm happy to answer them now. Yeah.
Okay, beautiful. So this is from Jenny Calick, and she's asking, has there been any discussion in DOER or elsewhere on whether a strict no extensions policy can create a potential conflict with procedural due process, as the core of due process is fundamental fairness?
I like where your head's at there. I would like to, I wish I could say that the state has really considered that issue, but ultimately I think that's an issue that's going to have to be litigated, and maybe I'll be the one doing it at some point. But yeah, I would agree with you. I think it does strike me that it'd be an interesting argument to make that there are due process concerns here. So that is TBD.
Okay, and then we have one more again from Jason Dorney, and he's asking, are solar panels considered impervious?
Yes. Yes, they are. Yeah, I mean, I've actually, I remember a case I had in, it was in Lancaster, where there was a large scale solar array that was right on the side of a hill. And at the bottom of the hill was a intermittent stream that then discharged into a pond. And during rain events, the intermittent stream basically became a river full of sediment that was discharging into this pond and causing all types of issues. So yeah, that they definitely, the slope of the panels increases the velocity of the stormwater coming off of them. So depending on the way that they're sloped, I mean, if they're on a site that itself has sloping, then that can definitely cause stormwater runoff issues.
So it looks like we have somebody who wants to ask a question in the chat, or in the to pull in and be able to speak. So I'm gonna allow her to speak. It's Carol McNeary from the Conservation Commission.
Great.
All right, go ahead, Carol.
Couldn't it be the case in some municipalities that the capacity of the government itself or its boards or commissions, that they find that they simply can't accomplish all these tasks in time?
Mm-hmm. Yes, and I there certainly will be smaller communities throughout the state that run into that issue. And unfortunately, when that's the case, the state will be all too happy to take care of it for them. So
Okay.
yeah. Yeah.
I didn't mean to cut you off there, Alex. I wasn't sure if you were done.
Yeah, no, that my understanding is that if the community does not have the ability to appoint someone as a local government official, and can't, oversee the local permitting process themselves, um, then the state and it takes over the whole process at that point.
Carol, it looks like you have a follow-up maybe?
Yeah. And couldn't it also involve significant costs for municipalities, particularly when they say they're mounting an appeal or having to hire more people?
The short answer is yes. Yeah, it's these types of appeals are very costly. You're talking about hiring experts, significant amount of legal fees and expert fees. So unfortunately, it's not an inexpensive prospect to pursue these types of appeals.
Okay, so I'm gonna remove Carol, but Carol, if you have any follow-up questions, please let us know. And it looks like all of our questions are gone for the time being, so if you want to continue, Alex.
Okay. All right. Let's see. Where were we here? All right. Oh, looks like we're at the end. All right. Well, yeah. I mean, I'm happy to answer more questions. The recent or the amendments from the 2024 climate bill, as I noted earlier, KP, we're working on some kind of comprehensive guidance for all of our clients that will highlight what the more specifics of the process than I've gone into tonight. And we're also working on model bylaws that hopefully will help inform consideration of potential amendments to your existing bylaws, or maybe some potential tweaks to the solar bylaw that you've already been working on. And we're more than happy to work with you guys as you move towards implementing that bylaw. Both myself and I know some of you have worked with my colleague Carolyn Murray. We're both two of the solar experts at KP, and we're happy to work with folks as you work towards implementing this new process and implementing your new bylaw. So with that, happy to answer any other questions.
Yeah, this is a really excellent opportunity for us to hear from you, Alex, and get our questions answered. So we're really grateful. And it looks like I see some hands popping up. So first, I'm going to pull in Stephanie Ciccarello, our sustainability coordinator.
Great.
Go ahead, Stephanie.
Thanks, Erin. Hi, Alex. Nice to meet you.
Hi, Stephanie. Nice to meet you.
So I have more of a, well, it's kind of a comment and question. So I did attend the DOER information session on the draft guidelines last week. And one of the questions I believe that came up was that if one of the boards or committees does not meet the 12-month timeline, so let's just say Concom for whatever reason doesn't get their permit in time, but other boards and committees do. Does that automatically render the permit, or does it automatically go to constructive approval by the state? Because ultimately one of those is
Yeah,
missing.
so that's a good question. And I don't know the answer at the moment, but I will absolutely get you the answer. My my inclination is that that the state would accept reasonable conditions or incorporate reasonable conditions uh, from the boards that rendered conditional approvals and incorporate those into the final permit, uh, but probably, I guess, incorporate whatever their standard conditions or criteria will be um, for the aspects of the project from the board that did not meet the deadline. Um, but but it's a good question, and I will definitely get you a specific answer on it.
Thank you.
I thought I saw another hand up, but it looks like it came up and came down. Oh, I see Bruce. All right, where'd you go, Bruce? All right, I'm gonna allow you to talk. Hold on one second. All right, Bruce, you should be able to speak.
I put it in the question and answer, but basically, are there any legal groups that are out there to help these circumstances where there's legal questions and an appeal, like Conservation Law Foundation, but there could be others, so that the small towns aren't basically just told, you have to do what we tell you. And if they want to appeal, they'd have to have help.
Well, at KP, we would be glad to help them if they reach out to us. I anticipate we will be helping many of them navigate the process. I'm not aware of any kind of nonprofit groups or anything like that that are, at least at this point, teed up to help with that process. But I do foresee KP Law having a role in helping some of those smaller communities going forward.
I see a couple other questions that have popped into the written question section. So I'm going to read through those. One of them is from Scott Cashin, and he says, state law prohibits municipalities from regulating solar installations except where necessary to protect the public health, safety, or welfare. This regulation seems subject to interpretation. Have there been any court rulings pertaining to what constitutes public health, safety, or welfare? Studies after Moss Landing BESS fire indicate the risk to public safety can extend well beyond a project's boundaries, so the argument could be made that any BESS could impact public health, safety, or welfare.
Yeah, those are good points, and those are the exact arguments that I'll be planning to make in the land court in the next couple months. On a couple of permit denials, one of them for the town of Uxbridge that will probably be coming to a head in the next couple months in land court. And yeah, one of the arguments I'll be making there is that in the case of a fire, there absolutely will be significant impacts to public health and safety, not to mention the impacts, at least in that area, on the groundwater table, where the project, when it's at full capacity, the amount of water that's needed to cool down all the batteries is significant, and is anticipated to have a negative impact on the groundwater table in the area. So again, that's another health impact. Yeah, I think it's going to come down to a question of a battle of the experts, and um, hopefully I'll be able to convince the land court judge that yes, there will be significant negative, or at least could be negative impacts to health and safety from these types of projects, particularly when they're sited, as this one is, right next to a residential neighborhood.
So before I go on to the next question, just want to make a correction. Stephanie Ciccarello is our sustainability director, not our sustainability coordinator. So I wanted to make sure I corrected that because I misspoke earlier.
Got it.
Our next question is from Jeff Bagg, and he asks, is it possible to estimate when the guidance / models will be available?
Uh, soon, I would say within the next, hopefully in the next couple weeks. We have a draft bylaw that is in decent shape now, but we need to update it based on the recent regulations that came out.
Okay, we have an anonymous question, which is any insight into when the finalized state rules will be released?
Yeah, that I'm not sure, but I would say that will likely be soon as well. Yeah, because again, the plan is that all the new permitting requirements will go into effect as of October 1st of this year. So so the final regs will definitely need to be in effect before then.
Okay, the next question is from Steve Roof. Can a solar development applicant appeal a permit denial by a city or town, and what's the appeal process?
Yes, they can. At this point, the appeal process depends on which permit is denied. So, so from a wetland perspective, if an order of conditions were denied under the state act and the Amherst bylaw, there would be two appeals. One would be to DEP requesting a superseding order of conditions, and the other appeal would be to Superior Court appealing the bylaw denial, and that would be what's called a certiorari appeal under Chapter 249, Section 4. That's a record review appeal. So basically, once the appeal is filed with the court, the Concom would have 90 days to compile the administrative record of proceedings, which is basically all documents that the commission reviewed during the public hearing process, any correspondence that was submitted, copies of meeting minutes if they're available, agendas, a copy of the bylaw and local regulations. Aaron would send me all that, and then we would put it in a binder, organize it with a table of contents, file one copy with the court, send one copy to applicant's counsel, and then that would trigger a deadline for the developer's counsel to file what's called a motion for judgment on the pleadings, where they would argue why they believe the denial was arbitrary and capricious and in exceedance of the commission's legal authority. And then we would have 30 days to respond on behalf of the commission about why the decision was lawful and should be upheld. And then the court would schedule oral argument and then render a decision at some point a year or year and a half after the case is filed. And then from a zoning perspective, if the ZBA or planning board were to deny a permit, the appeal would be under Chapter 48, Section 17, and that would go to Superior Court or Land Court, and would be a de novo review. And ultimately, I guess it's possible that the case would be resolved through motion practice, but if there are factual disputes about certain aspects of the project, then you may ultimately need to go to a bench trial to have the judge determine whether or not the ZBA or planning board decision was should be upheld. But as of October 1st, the new appeal process will be exclusively handled by the Energy Facility Siting Board at the state. So that will
And
be
that's if any one of the boards, committees in town who is part of the issuance process was to deny, it would go to the state siting
right.
board. And how would that work relative to our local bylaw? Would that process go to the state and then the bylaw would go to Superior Court if it was no? It would
Yeah,
all go to the
at
state.
this point, the regs at this point suggest that everything will go to the state.
Hmm. Interesting.
Yeah.
Okay. All right. I have another question from Steve Roof. Oh, I'm sorry. All right, I already got that one. Sorry, let me move to the next one. This one's from Hilda Greenbaum. Um, can't CBA put a condition on the permit relative to abiding by any condition um, for missing committee info that may not meet the timeline? I think what Hilda might be saying here is if there's a condition that information be submitted to the committee by a specific deadline and it's not submitted,
Mhm.
wouldn't that be grounds for, the ZBA potentially denying? I think. I think that's her question. Oh, hold on. She's
Okay.
raising her hand. Maybe she needs to clarify that.
Oh, uh,
Go
um,
ahead, Hilda.
what I want to know is, the Concom ran into the problem that you brought up before of not having quorums and things like that, so that you didn't get your conditions done in time to meet the 12-month deadline. Can the ZBA or other permitting board make a condition that the project has to comply with any conditions that the Concom comes up at some time in the future? So, words to that effect.
Um, I think the if the ZBA were to impose that type of condition, unfortunately, I think the state would probably strike it. Just again, um, based on what we've seen so far with the regs and what the OER said recently at their presentation, it really sounds like there's zero flexibility on the 12 months. So trying to impose conditions that aren't imposed before the 12-month deadline using a different board to do it is unfortunately probably not going to pass muster with the state.
Yeah, I have a quick follow-up to that, Alex. The Concom frequently and the ZBA or planning board, we try to review our projects in tandem. So, applications come in and I know typically the ZBA or the planning board will try to wait until Concom has sort of reached its approval phase because there's a lot of things like stormwater that apply to multiple committees and also multiple bylaws. So like if it holds muster with Concom, then that usually means it meets our local stormwater bylaw as well. And also, then it's kind of reached a point where planning or zoning could approve it. And so I guess it calls into question the whole timeline issue. Like if ZBA is in a position to approve, but Concom hasn't approved yet, it creates this situation of like sort of cart before the horse in the sense of like if there are, let's say ZBA approves or planning approves, but then there's changes in the plan with Concom,
Yeah.
then
So,
what?
yeah, and so that's where the local government official position is going to be important. That person's job really is going to be to deal with those types of coordination issues between the various boards. But yeah, I think maintaining that kind of simultaneous review is going to be important given the time constraints. But ensuring that the different boards are able to interact together and review the projects and I guess try to work together to the extent possible. That's all going to be under the purview of the local government official.
Okay. From Lenore Brick, she's just saying thank you for your hard work and important work. Uh, Thank you, Lenore. We do appreciate Alex's time tonight. This is really, really helpful. A, a comment slash question from Arlie. Old trees and forests store more carbon than new forests. How does that has that come into play for any project that you've permitted, Alex?
No, but it's a point that's well taken. I mean, if from a scientific perspective, we were able to get an arborist or someone else who could opine about, as an expert, about the value of older trees in terms of carbon sequestration, then yeah, I think that would definitely be relevant for consideration of the various boards. And if there were a subsequent appeal, I think it would be relevant to that appeal, definitely.
A comment from Stephanie Ciccarello, our sustainability director. More a note to Alex, but the regulations were promulgated on March 1st. They're final and in effect, is my understanding. Only the guidelines are currently under review.
That's right.
Okay.
I'm sorry if I mixed up the guidelines and the regs.
From Jason Dorney, one of our Concom members, can you define or provide an example of arbitrary and capricious?
Let's see. So, well, one situation that's always arbitrary and capricious is if a board issues a decision that has no reasons, just says, denied. Then the court is almost always going to remand that back and require the board to make some detailed findings. But conditions that I've had struck from boards' decisions before that are determined arbitrary and capricious are, things that just don't have any basis in whatever the bylaw is that's being applied. Trying to think of an example. Yeah, struggling to come up with an example off the top of my head, but I'll make a note I'll send you, Aaron, a follow-up email with answers to the couple of questions that I wasn't able to answer tonight, and I'll add some examples in there as I jog my memory about provisions that have been found arbitrary and capricious.
And just a thought, but this is just a potential idea is, I've had situations in the past where Concom members might bring up things that aren't relevant to Conservation Commission regulations, maybe
Yeah.
traffic or,
Yeah, exactly.
density or something like that. And so, like,
Yeah.
if a Concom denial was based on one of those factors, I would think that that might come into play.
Yeah, that's exactly right. I mean,
Yeah.
anything that is kind of outside of the jurisdiction of the board as defined by the bylaw that the board is applying would be considered arbitrary and capricious, and the court would likely strike it.
Okay. Okay. Let's see. Another question from Hilda Greenbaum. Can a permitting board negotiate with the appellant anything like approving a smaller project, etc.?
Yeah, I mean that's always up for discussion. I think at a certain point there are times where an applicant is kind of approaching the end of the permitting process, and they can kind of read the tea leaves and determine that sounds like if the project stays in its current configuration, they may be headed towards a denial. So if they have a savvy consultant or attorney who's working with them, then hopefully at that point they'll consider some alternatives and propose those to whatever board is reviewing the project. So yeah, those types of negotiations are always on the table until they're not. Until the applicant decides that they want to. If there are financial considerations, then they want to maintain it in whatever configuration is being proposed. Then they will proceed to an appeal.
And one of the things with Concom where this has come into an issue that we've been dealing with is I found it really important to emphasize if you're going to require something like that of the applicant, you should state what is missing or what the problem is, why it's necessary in order to comply with the regulation, and when you would expect those revisions to be submitted to you and provide a bit of a deadline. I think that that's going to become particularly more important as we move into this 12-month window where we're trying to say, okay, in order to make you comply with our bylaw or our regulations, we need for you to get us this very specific information if you're going to comply with our regs, and we need you to get it to us within, a reasonable period of time, but also enough time that we can receive it and review it before the deadline. So just
absolutely
those types of procedural things I think will become really important.
Yeah.
Okay. Wow, these questions just keep coming. And I'm not sure where if at any point you need to kind of put a fork in it, Alex, just say the word.
No, I'm good.
Okay. So I have a question from Steve Roof, which is rhetorical question for everyone to consider. Every year, pollution from fossil fuel generated electricity kills several thousand people in Massachusetts and causes over 15,000 cases of pediatric asthma each year, according to 2022 Boston College study. How do we compare the potential hazards of solar-generated electricity to the health hazards of fossil fuel-generated electricity? Anonymous attendee, I'm going to take this one and then go to Stephanie, who's had her hand up, and then I'll come back to the chat questions. This is an anonymous statement or comment or question. I would be interested to know why there is such a great need for increased electricity. Is it about the data centers and the AI and cloud storage? Has anyone asked why those uses are more important than clean air and water? Has anyone taken the position that using less might be a useful strategy, especially since Mass seems to be losing population?
Talk to your legislators. That's all I can say about that.
Absolutely fair. Okay, I'm going to go to Stephanie. Stephanie, you should be able to speak now.
Erin and Alex, I just first wanted to thank you so much for taking the time to do this and for your expertise. It's really helpful. And Erin, thank you for organizing this. Just wanted to give you both kudos first. But I had a question about the timing of all this. So and this is why I sort of brought up the point about the regulations being promulgated March 1st, because so in essence, they're in effect now.
Yeah.
And communities or applicants can choose which pathway they want to submit an application. But if a community is not ready, is that correct? Or
So my understanding is that while the regs are in effect now, that the new permitting procedures, if you will, don't go into effect until October 1st, I think it is.
right, that's when we absolutely have to have our process ready. But
Yeah.
I keep hearing the comment made that, and I think maybe July is the point at which maybe it's July 1st that applicants can choose which pathway to submit. I know there's a July
Yeah,
1st.
that would make sense, because then you'd have the time for the state to do the citing their review, I guess, beforehand.
Right. So I guess I'm still sort of confused by that process, because
Yeah.
say an applicant in July decides, okay, I want to do this new, comprehensive one permit
Yeah.
pathway.
That's
what do
another
communities
good
do?
Yeah, that's another good question that I'll get you a specific answer on. The question being, when can applicants start electing to use the new process?
Yeah, that would be helpful for us to know. And I know we have many board and committee members on this session, so I think it would be really helpful for them to have a heads up. So thank
Absolutely.
you.
We'll get you the specific date of that, definitely.
All right, looks like we have two more questions. Another from Jason Dorney on our Concom. Would perceived or expected impacts due to increased runoff to wetlands, intermittent streams, vernal pools, other resource areas be considered arbitrary or capricious?
No, I think that those concerns are exactly the types of issues that the Concom should be concerned with.
And then anonymous attendee, within the 12-month timeline in place, what is the place to prevent the applicant from dragging their feet to run out the clock / force approval?
Good question.
That is a good question. Yeah, I mean, so I suppose ultimately what would happen is, well, I guess based on what we know at this point, if the state is not going to waive the 12-month deadline, then we would have to convince the state energy facility siting board that the applicant was acting in bad faith when they were pursuing their local permitting. And I'm not sure, I'm actually going to write this question for myself to look into, is whether or not we at that point would be able to ask the state to remand the project back to the local boards with directive from the state that the applicant, act in good faith and answer the reasonable questions that the boards are making. So I will look into whether we think that the EFSB would exercise that type of authority to require a remand. But that is a good question, and I think that at this point it seems like we would still be at the mercy of the state, but we would at least be able to make the argument that the applicant was acting in bad faith, and so the state should direct them to provide information that's being requested, and that hopefully the state would be willing to remand the project back under those types of circumstances.
Yeah, and that to me seems like something where the arbitrary and capricious could come in, because if a commission said, for example, we want these materials submitted to us in 12 months, or 12 months, excuse me, 30 days, just to use an example, there's nothing in the regulations that says applicants have to get back to us with revisions within 12 months, but if we're getting the revisions back and we might need to have a peer review on them, we have to have that timely. It's like a dance, but there's nothing in the regs that specifies that. So I could see that being one of those arbitrary and capricious issues where somebody could argue it's not reasonable, but the commission's still trying to advance it through the process in a expeditious way.
Yeah, I mean, again, I would hope that, and a lot of this is just going to have to evolve through trial and error. But if an applicant is not providing information that's requested in a reasonable time frame, I would hope that the state would require them to do so at the local level and not just take over the project review at that point. But that remains to be seen.
And this is just, Carol has her hand up and she's been waiting, but I just want your opinion. What is a reasonable time frame, Alex, from a legal standpoint? What's a reasonable time frame to request revisions to be resubmitted by in a situation like this where commission or committee requests it?
By the next meeting.
By the next meeting?
I get, well, I mean, I guess it depends on the scale of the change, but if the state's going to require this type of expedited time frame, then yeah, I mean, reasonable is ASAP.
Okay. All right, I'm going to pull Carol in because she has her hand raised again. Did I get you, Carol?
Yeah, thank you. This is a different area, but a very similar situation from what I've gathered. I was interested in the Mass Ready Act, which was being proposed in fall, and it's changed in some way, I know, but its purpose is to promote, instead of solar facilities, to promote special types of housing. And there are very similar changes in the types of permitting, timeline, etc., appeals, very similar to what you just told us about. And I bring it up because I think it's something that one way or another we need to be prepared for.
Okay. So it looks like we don't have any further questions. If anybody has anything, oh, hold on, one more. Jeff, our economic development director, just jumped off and he said thank you. I just want to express my gratitude to you, Alex. I know one of our commissioners requested this opportunity to ask questions and hear from you. And so I think it's been, just by the number of questions, I want to say we've had some, 35, 40 questions tonight. Just by the interest and the level of questions, it's just been fantastic. And so thank you so much for your time and expertise on this. And thank you so much to everybody who took time out of their evening to come tonight. And really, really appreciate it.
Well, thank you, Erin, for making this happen, and for everyone's thoughtful and important questions that I'm sure are just the beginning. We definitely are starting kind of entering a new frontier in terms of the permitting process here. And I'm sure there will be many more questions coming down the pipeline. And, that's what we're here for at KP. And I look forward to working with you all going forward. And I'm sure we will be back in touch soon. So I did write down the questions that I wasn't able to answer tonight. Aaron, I will follow up with you by email and get you some specific answers to those questions, and happy to answer any other questions that come up too.
Great. And is it okay for me to share your presentation with anybody who reaches out to me or folks who are on the invite list for this training tonight?
Absolutely. Yeah.
Okay, fabulous. All right. Well, thank you, everyone, and stay safe out there on the roads tonight if you're driving. And thank you so much, Alex, once again, and have a great night, everyone.
Thanks, everyone.
Take care. Bye-bye.